Good morning, Mr. Blon.
Thank you, Your Honor. I represent Capital One Bank and Capital One FSB, and they're here today to ask for reversal of the Appellate Tax Board's decision that Massachusetts had jurisdiction to tax those banks which are domiciled and based in Virginia and conducted a credit card activities business in Massachusetts. The issue in this appeal is whether Massachusetts has jurisdiction to tax the two banks. That depends on the application of the Dormant Commerce Clause provision, which limits state taxation, which unduly burdens interstate commerce. The criteria for the application of the Commerce Clause is set forth in a Supreme Court case, Complete Auto Transit, which lists 4 criteria, only one of which is at issue here.
How old is that case? What's the date of that case?
That case is in the 1977.
Well, yeah, and hasn't the court swung more to a federalism approach on this issue now?
More towards what, Your Honor?
Federalism.
No.
Allow the states to have more independence in taxation and other things.
The criteria that have been laid down in Complete Auto Transit are 4, and they have been consistently applied on a case-by-case basis. But the one criteria that's an issue here, substantial nexus, has been litigated a number of times in subsequent years, and in each Supreme Court, in all Supreme Court cases that have applied the substantial nexus standard have required a physical presence in the taxing state.
But isn't it possible that with the changing times and changing technology, physical presence just doesn't mean what it did back when, what is the case, Quill was decided, or the other one? Complete Auto, I'm sorry, Complete Auto was, because now your company is targeting customers here. It makes millions of dollars from here. The people in Massachusetts are writing checks, paying interest, and you're accepting the money, you're accepting our checks, and why shouldn't that be the equivalent of a physical presence?
Well, the exact same argument was made unsuccessfully in Quill.
But
North Dakota made exactly the same argument. It was rejected. And the reason is that
But that's a sales and use tax, and this is not. And I think it's possible to read Quill as, I know you don't, but there is certainly language in Quill that suggests that the court was not foreclosing the possibility that ruling was limited to sales and use taxes.
Just finishing on the last question first, Your Honor. The reason is we need a national standard for substantial nexus. We can't have a state-by-state nexus standard, which is what the Supreme Court has tried to do by saying physical presence. Now, in the second part...
But could change it. I mean, this is years later.
The suggestion has been made that that the Supreme Court in Quill limited its holding to sales and use tax. I think that's what Your Honor suggested. And I think the answer to that is not so. In Quill, the court said, it reaffirmed National Bellahasas, which had been cited 25 years earlier, insisting on substantial nexus in a sales and use tax case. And it then responded to the court of North Dakota, which said, well, subsequent cases like Complete Auto Transit have eroded the physical nexus requirement, and the Supreme Court said that's not the case. In every single case that we have had before us, we have never upheld substantial nexus without a finding of physical presence.
If a company out-of-state company is selling products in Massachusetts, would that be enough of a nexus?
Well, if you still need physical presence, but even there, Congress has carved out a limited exception to physical presence in the Public Law 86-272.
Because you have products here in Massachusetts, do you not?
We have we do not have physical product. We have credit cards, which customers use in Massachusetts and elsewhere.
Each credit card, of which there are perhaps thousands or hundreds of thousands, in my opinion, is a product that people are walking around with that gives them access to cash and credit.
Don't you sell credit cards as products? Do you call credit cards products?
No, the credit cards themselves are simply a representation of an intangible right. It's the number on the card that is important to secure credit. Many credit card transactions are effected without the card over the telephone. It's just the number. It just embodies a right to secure credit from an out-of-state bank, which does not otherwise have any property or personnel in the state.
Are acquiring banks in the scheme of the credit card system are acquiring banks that I take it Capital One has to go through, and which I also take it are Massachusetts banks. Do they constitute physical presence?
If an acquiring bank has a branch in Massachusetts, it of course has a physical presence here. The acquiring bank has the contractual relationship with the merchant. Capital One here is the card issuing bank, which is a further step down the chain.
Is it your position that only Virginia has the right to tax Capital One?
Yes, only Virginia or any other state in which they had a physical presence. But if you stipulate they did not have a physical presence in Massachusetts, then as regards to Massachusetts, only Virginia can tax them.
They operate all over the country, but only Virginia can tax them.
By the same token, yes, Your Honor, but by the same token, Massachusetts domiciled banks have the same protection under the Constitution.
Another question. Am I correct that the West Virginia case, cert was denied? Is that
Yes, cert was...
Has cert been taken in any of these cases that have been decided on in a different way than you are arguing for?
No, Your Honor. There are two cases exactly in point. Credit card banks, no physical presence in the state where the credit cards were used. In the state of Tennessee, it upheld the application of Quill. It said that there's no principled basis to distinguish a sales tax from a franchise or income tax. And in that case, the Constitution...
Isn't that the real question, whether there is a principled basis to distinguish between the sales and the use tax on one hand and the income tax on the other? And I know Mr. Barnacle makes some arguments in his brief, but isn't that the real question? Because clearly the United States Supreme Court has said that we can't tax sales and use taxes without a physical presence, but they haven't so clearly said that you can't tax income taxes without a physical presence. Your interpretation is that they have said it, but it isn't as clear. And so the question is, can you distinguish between the sales and the use tax on one hand and the income tax on the other?
Some of the courts have attempted to do it by discussing the burden that's imposed in compliance with sales taxes as compared with income taxes. But I think it's very clear, at least, that the income tax burden is substantially greater. The sales tax is a postcard return. I think it's got 7 lines on it. Income tax returns run hundreds of pages, involve hundreds of judgments about the computation of the tax base, the computation of apportionment factors, what kind of institution are you, which franchise tax are you subject to. The burden, and indeed the Supreme Court noted that in the National Geographic case, that the burden of compliance with income tax laws is substantially greater than complying with sales tax laws.
But hasn't the Supreme Court in Quill it's essentially opened the door to the approach that the Commonwealth is taking and that other states have taken when they said that they were relying on the national Bellis standard because it engendered substantial reliance on by a particular industry, the trucking industry, in sales and use taxes.
Stare decisis was a feature of the case, but the court also went on to re-examine the bright line rule that Bella Hess had laid down, that you have to have physical presence. And they reaffirmed it, and they said it furthers the goals of the Commerce Clause. Now, the problem is, you take the Massachusetts statute, which says you have nexus, you have substantial nexus if you have 100 customers in Massachusetts. The problem is that that's not a national rule. The Supreme Court wants a national rule which is easily administered, and that's physical presence. Now, they did say in Quill that the reasoning of all of their income tax cases is consistent with Quill.
But I'm sorry, you finish.
No, I'm done, Your Honor.
I thought also, though, the court said in Quill that, as you say, stare decisis was a factor, and there was language that in other kinds of tax cases we have not followed this bright line rule. That is, other than sales and use.
No, I think the phrasing, Your Honor, was we have not articulated a bright line rule, but they went on to say the reasoning in those cases is perfectly consistent with Quill, or with National Bellis Hess, and therefore with Quill, which reaffirmed National Bellis Hess.
Why wouldn't they have taken cert or granted cert in the West Virginia case?
I don't know, Your Honor. They denied cert in the Tennessee case, upholding the application of the Commerce Clause to bar the state of Tennessee from imposing taxes on an out-of-state bank issuing credit cards.
My point, they're now swung into a position, it seems to me, that they're allowing the states to do what they want under federalism principles.
That has to be an implication based on a denial of certiorari, which is not the common understanding.
I know that, but
Yeah. But if you're right, wouldn't the West Virginia case wreak havoc on interstate commerce?
Yes.
So why wouldn't they grant cert?
I do not know, Your Honor, but I do agree with the havoc. The standard in Tennessee was soliciting or acquiring 20 customers. That is a substantial thing. All West Virginia did, really, was substitute economic presence for physical presence, and then it merged the due process clause with the commerce clause and essentially made them the same standard.
But that's what you're saying the appellate tax board did here.
Exactly.
That's your argument.
That's exactly what the appellate tax board did here. Made the due process clause and the commerce clause merge because you apply the same standard. I mean, all of the conversation in the appellate tax board opinion about economic exploitation of Massachusetts, targeting customers, all of it was beside the point, because the Massachusetts statute says you have substantial nexus if you have 100 customers. Doesn't matter how you acquired the customers, they could have moved here.
does the record show how many customers you have in Massachusetts?
The record does show that they had some significant numbers of customers, close to four. In one case, in Capital One, they had around 450,000 customers, and in the other one, they had less than, I think, 8,000. Capital One FSB, less than 8,000. But that goes to the point that a bright line rule of physical presence will protect some large out-of-state companies.
Is there
And some
anything in the record that agents on their behalf are selling these cards in Massachusetts? For example, when kids go to college and the first week orientation, is there a Capital One desk? Is there any?
Say again, Your Honor.
Well, is there any indication in the record that they have agents physically selling these cards in Massachusetts?
No, Your Honor.
Okay.
The board tried the case on the basis of no physical presence. Indeed, it assumed, if you read the opinion, it assumed they had no physical presence, no attributional nexus through dependent agents, no physical plant, no employees, no agents, independent contractors that would provide attributional nexus.
If we should decide your way, are we harming Massachusetts banks?
You're benefiting Massachusetts domiciled banks because the Commerce Clause physical presence requirement protects the remote out-of-state vendors, but it also protects a Massachusetts domiciled bank when it engages in similar activities without physical presence in other states. It's an even-handed
Other states
rule.
follow the law, the rule that we decide, if we decide in your favor. I mean, as I see it, there are a variety of opinions out there.
And also, I'm talking about Massachusetts banks that are local and don't really do interstate business.
Banks with physical presence are subject to taxation.
Right, so.
Banks without physical presence are not. But it works that way for Massachusetts banks, which do have physical presence here. They have the same rule. I mean, in a sense, Virginia has a right to tax 100% of capital banks' income and without any apportionment, because the banks you apportion income if you're taxable in another state. If you're not taxable in another state, you don't get to apportion income. I mean, while Massachusetts thinks it has a clear rule, I mean, the appellate tax board, 7 or 8 months after deciding that the Massachusetts statute could constitutionally be applied to Capital One, an out-of-state bank, then turned around with an in-state domiciled bank, Fleet Funding, and decided that another state could not apply the same statute to a Massachusetts domiciled bank, and therefore that bank was denied the right, that Massachusetts domiciled bank was denied the right to apportion. In Fleet Funding, the bank was domiciled in Massachusetts. It said that it had the right to apportion, which is dependent upon being taxed in another state. It had more than 100 customers, more than $10 million in assets, more than 500,000 in receipts in a number of other states. And therefore, applying the Massachusetts Economic Nexus statute was subject to tax in those states, in principle. The board said, no, that's unconstitutional for another state to apply the same standard. Why? Because they said, the Fleet Funding was not engaged in market enhancement activities in those other states. That's not a condition that's in the Mass statute. And in fact, on the facts they were engaged in.
What about the fact that many, if not most, of your Massachusetts customers are probably writing their checks on banks with offices in Massachusetts?
I don't see where that affects Capital One. Capital One,
Getting your money that way.
Capital One, there's no question Capital One receives receipts from Massachusetts customers, but it does not have a physical presence here, and that's what's required.
Well, if you didn't have any money, you wouldn't be operating. And you're getting your money from people who are here in Massachusetts.
They do get money from customers in Massachusetts, but that does not confer nexus. There are a lot of remote sellers, Amazon.com, Quill, a lot of remote sellers have secure funds from Massachusetts, but that does not confer nexus because you can't apply that standard nationally.
Mr. Brown, I know your time is up, and I saw your reply brief, but I wonder if you could succinctly tell me why you think the trademark cases have no application here.
The trademark cases all involve a particular an out-of-state company
Right.
holds trademarks. It licenses an affiliate that is conducting an in-state retail business. It then exploits those trademarks to sell licensed products, and it provides employees, physical plant, and in selling the products, it enhances both the out-of-state trade, the value of the out-of-state trademark, and the sales of its own licensed products. And in that way, it gives attributional nexus to the out-of-state company, a factor that is not present in Capital One's case.
Thank you, Mr. Brown. Mr. Barniker?
May it please the Court, my name is Thomas Barnico, Assistant Attorney General, and I represent the Commissioner of Revenue.
Mr. Barnico,
in this
could you
case.
explain the apparent contradiction, and maybe I don't understand the fleet funding case very much, as Mr. Brown has described it, between fleet funding and Capital One?
Yes, Your Honor. We don't read the decision of the Board the same way that he reads it. I don't think the Board made a square constitutional ruling. In fact, if it did so, it would be casting doubt, I think, as he alluded, on one of the prongs of the financial institution's excise.
Right.
So we don't read it that way. That case is pending in the appeals court. Our brief has not yet been filed.
Well, how do you read it? I mean, did the Board say that, no, the other states couldn't tax fleet funding?
I think they
in a way
said
that we say we can tax out-of-state banks, and therefore they couldn't deduct that or apportion that income?
certainly the latter, that they couldn't apportion, but not squarely that the constitutional rule cast the statute in doubt. Rather, they said there was a failure of proof. The fleet funding, after all, in the facts of this case, had filed its return claiming 100% apportionment to Massachusetts. It was only later that the issue of whether they could apportion to other states arose. There was a failure of proof as to the nature of their activities in the out-of-state circumstances, and that's where I think Mr. Brown's reference to the other activities of the loan origination and all the rest arose. So,
I mean, it seems to me that this does scream out for a national standard of
Right.
substantial nexus, because you're going to get into this mess more and more.
well, that's, I think, where the Dormant Commerce Clause comes in, and some of the references to federalism come in as well. And that is, in a sense, what's before the state Supreme Courts that have wrestled with these questions after Quill is one of federalism and the question of who should impose that national rule. Questions of deference and federalism here are really grounded on the notion that it's Congress, under its power, under the Commerce Clause, that can step in and set the national rule when interstate commerce, it needs to be protected.
Well, Congress can, but if Congress doesn't, there's absolutely no reason why a court cannot. And the fact that, and
right.
frankly, the fact that the Supreme Court has denied certiorari doesn't mean anything to me. Quite often, the court will wait until there are 2 or 3 states to see
Right.
how this is going. I mean, I take nothing from the denial of cert.
I agree with that, Your Honor, although I'm not aware of a denial in the Tennessee case. That was a case involving an intermediate appellate court.
And I'm
is
talking
West
about the
Virginia.
I'm talking about the West Virginia case.
Yes. And
Could I ask you, because it seems to me this is where the case really boils down to this. What are the real differences between the sales and the use tax on the one hand and the income tax on the other? Because Quill certainly speaks to sales and use tax. It's got to have physical presence. And as I said before, then there's a question of whether Quill is also speaking to income tax. And arguably it is, and arguably it isn't. But it would help your position if you could say, well, Quill is only speaking to sales and use taxes because there is a distinct difference between them. And I see in your brief, I read your brief, the administrative burdens, et cetera, et cetera. But to me, I wonder if there are there any more, or is that the best you can come up with?
What's in our brief is what other courts have said in comparison of the burdens. But I don't think that's the path to this court's decision. And let me explain why. And it has to do with starting your inquiry at National Bellis Hess in 1967. That's when the Supreme Court determined, under the Commerce Clause jurisprudence at the time, that there was an undue burden on the out-of-state companies whose only activities in the taxing state were solicitation through the mails and delivery by common carrier. Now, Quill Complete Auto, as was mentioned, arrives in 1977. That establishes by any doubt that interstate commerce may be made to pay its own way by the imposition of state corporate income taxes like we have here. Quill comes along in 92 and says very significantly, National Bellis Hess may not have come out the same way under contemporary Commerce Clause jurisprudence in 1992. Nevertheless, as a matter of stare decisis, we say, Quill upholds the ruling in National Bellis Hess, being very careful to limit it to Commerce Clause grounds, making clear that the Due Process Clause is clearly satisfied by these out-of-state sellers, and reaffirming the National Bellis Hess rule, but only in that context. Now, that gets me back to your question, Your Honor, in this respect. That demonstrates to us that what's before the court, as each of these state courts that has wrestled with this, is not a current or de novo comparison of the respective burdens between the imposition of use taxes on the one hand or corporate income on the other. Of course, we briefed that issue, but we think the path to decision instead is to simply say that National Bellis Hess was the time frame for the comparison. The Supreme Court reached its judgment at the time, found that undue burden, never mentioning, by the way, the term substantial nexus. That was reaffirmed as a matter of stare decisis in Quill, but carefully limited in the sense of the reference to contemporary Commerce Clause jurisprudence, and also what Justice Bosford referred to as the language has not, in its review of other types of taxes, articulated the same physical presence requirement.
Is it your view that in this case, the nexus required under the Commerce Clause is qualitatively no different than the nexus required under the Due Process Clause?
Our view is that in certain cases it can be no different.
No,
that is,
how could you say that?
in the sense of the quantum of evidence necessary to show the substantiality of nexus. I acknowledge that the plaintiff's bright line rule shows a difference in kind. That is, the presence.
I can think of countless situations where you would satisfy, and I don't think there's a claim here, although you spent some time in your brief, that this doesn't satisfy the Due Process Clause. Right? So, it can't be, sometimes you may satisfy the Commerce Clause and not the Due Process Clause. Sometimes you satisfy the Due Process and not the Commerce, and sometimes you satisfy both. But they're two different inquiries.
Well, they're different inquiries, but I think in certain cases, Your Honor, the evidence will be the same.
Well, I don't question that, but the evidence may be the same.
You're just saying that as a factual matter, it may satisfy both. You're not saying it's necessarily the same, or are you?
It's never, no, it's not necessarily the same.
No, it's not
Yeah.
the same.
Right.
The same facts
Right.
may satisfy both, but it's not the same.
That's correct. And the court uses the word different, although in a couple of other instances he's referred to them as related or closely related.
Sure.
Mr. Barnico, if I understood what your answer to Justice Cowan, but this is, I thought you were basically saying Bellis Hess was decided when it was decided, and essentially we are in a place where state courts, because the Supreme Court is letting them, and the dormant, and Congress has not stepped in, so the dormant clause is operative, are figuring it out. Is that, I mean, I don't get a standard out of that. I'm just, it's sort of like time has passed, so we're in a new world, but where's the standard?
Well, the standard remains substantial nexus, and I think that...
No, but how do you define substantial nexus? In other words,
Well,
I thought you were saying that the tax, does not unduly impede the flow of interstate commerce. Well, isn't that your standard?
No, you're on the terms at the outset. Of course, the standard is the definition of those terms. Nexus is defined by blacks as a connection or link, often a casual one. You add the term substantial to that mix, of course.
But doesn't that mean, as a practical matter, that all 50 states could then tax Capital One and a number of other credit card companies because they're in all 50 states?
If they're in each of the 50 states doing exactly what they're doing in Massachusetts, the answer is yes.
Well, doing what? Having more than 100 customers?
Or having more than 20 customers or 5 customers?
Well, throughout the case law in this general area of nexus, both statutory and constitutional, there's always a de minimis exception.
Yeah, so 5.
Well,
Small state, very small state.
what the legislature, I think, has given more guidance than some other states in establishing those thresholds for the presumption.
No, but I'm just asking you, different legislators, Massachusetts has said 100. How many citizens do we have? How many residents do we have?
6 million.
Yeah, so
Right.
it's tiny
So-
portion.
So if the nexus is established in all 50 states because they've got, enough customers, which they probably clearly do, doesn't that affect commerce negatively?
Oh, well, it certainly does, Your Honor, but that's
in a bad way?
That's our submission is that's for in most instances that'll be for Congress to decide.
Going to let them apportion?
Well, it's also
Absolutely,
apportionment, right?
And not an issue here is whether the fair share is obtained by each state through fair apportionment principles. Not at issue here, but we'd submit that those other prongs, which are all met here, the other prongs of complete auto, this tax must be facially non-discriminatory.
No, nobody's challenging those.
No, but there's a guide in there, Your Honor, and that is, I think it's fair to say, as the United States Supreme Court Commerce Clause jurisprudence has evolved, the focus has been on questions of facial discrimination or unfair apportionment. It's in this area of undue burden on commerce where the court has been extremely reluctant to extend when a non-tax situation, for example, the so-called Pike balancing test. This is where the deference and the federalism is at its height. I know this is a tax case. It's specialized in this way. But the court, I think these state Supreme Courts that are coming to the question of substantial nexus and coming to the question of an alleged undue burden on interstate commerce have shown some caution because they realize that this is an exercise of...
Seems like such a loosey-goosey test, like Judge Botsford said. It's, like the state saying, well, they're selling their credit cards here, they're making a lot of money, they're advertising on our television, we need tax revenues, let's go get them. What the heck kind of test is that?
Well, I guess...
It's an electronic age, so everything's a new miracle.
The term, I think, was used for the first time in the case of complete auto, setting out...
In the nexus test?
The reference to substantial nexus. Nexus was always part of, stepping back into the history of all this, of course.
How far back are we going? I thought we were going back to the original intent of the founders.
Right.
And you're messing me around with National Bell of Us in 1967. I mean, that's just a nod and a wink. Let's go back.
Well, this time I'm landing somewhere in between.
That won't satisfy at least one justice on the United States Supreme Court.
But to focus in between for a moment, complete auto settled up long-standing disputes about the extent that states could tax interstate commerce at all. Pure interstate commerce, indirect burdens, direct burdens. It was all chucked out at complete auto. One of the tests was this fairly vague aspect of substantial nexus. I think the reason why these cases didn't arise earlier was because if you had a rule that prohibited most state taxation of interstate commerce, then it was extremely rare that you could ever encounter a set of facts where there wouldn't be any physical presence in the taxed entity somehow survive those threshold prohibitions that the Supreme Court had developed and then later rejected.
I take it no one has fashioned a test in between substantial nexus versus physical presence? Because on the one hand, the nexus thing seems, kind of loose. On the other hand, physical presence seems unrealistic in this day and age. Is there anything in between that could be more concrete?
What is the term you use, economic presence?
Well, that's the term that the West Virginia court used. I think the board used it in passing. We think the better focus is actually on the word activity. That's the word in complete auto, probably repeated.
Economic activity within the state?
Yes.
Of a substantial
Of a
nature.
substantial
How
nature.
do you define substantial? In those,
Well,
in
it's
that
a
definition?
case-by-case analysis, and I return then to, I think the Supreme Court in Quill, it all gets back to, what you make of that decision. And I think the court, realizing how the vagueness of that term, lodged the inquiry in the Commerce Clause so that Congress could step in as necessary. For the rest of the cases, and of course this is our interpretation, but for the rest of the cases, deference would prevail, federalism would prevail. It wouldn't take a lot to tax a company. It wouldn't take a lot of discussion to tax a company like Capital One in the future on base of a portion share of its net income.
Can I ask you this question? You mentioned Quill again. I go back to that language in Quill, which is so curious. In our cases subsequent to Bellis and concerning other types of taxes, we have not adopted a similar bright-line physical presence requirement. Interesting statement. Then I go to Tennessee in the J.C. Penney case, which is 8-9 years later, and the court says there is no Supreme Court case which has upheld a state tax where the out-of-state taxpayer had absolutely no physical presence in the taxing state.
Right, and that's where that in-between history comes in, is I think you have this very large gap where, because that would have been seen in the older version of all the tests through the 20s, 30s, 40s, 50s as something that, for example, the states might not even try. But when
So I'm wondering what cases
it's referring to.
Quill is referring to that Tennessee says doesn't exist. Don't exist. Cases of other taxes in which the court has said physical presence is simply not necessary.
No, I agree with Your Honor about that's a difficult part of Quill to understand, because I don't know the cases either in that respect.
Can I just ask, I'm sorry, one question. Your argument does not depend on the statute on its face. In other words, that 100 customers would be enough. It's that as applied in this case on these facts, you're saying that makes a substantial nexus. Is that?
I think we're saying both because of the nature of the plaintiff's argument. In that, because the plaintiffs insist that, as a matter of constitutional law, physical presence is required, then it's facial in that respect. It just so happens this record goes well beyond the minimum thresholds. But
Mr. Barnacle, could I ask you one other question? It seemed to me that what comes closest to what your claim is the dissenting opinion in National Bellis House, Hess,
Right.
which really talks about the solicitation of consumers. Right. I mean, I will acknowledge that was material goods.
Right.
That's a dissent. Right. And it's pretty clear. I mean, there should be no doubt that this large-scale, systematic, continuous solicitation and exploitation of I mean, that's a dissent.
That's right, and Mr. Brown was correct in pointing out that the North Dakota Supreme Court, in a sales and use case, took the passage of time and technology to mean the dissent was right. We think the dissent is right now. That's correct. Quill then affirms, we say, because of reliance interests.
There are some very strong opinions, not just one, more than one, that essentially say to federal intermediate appellate court judges and state courts, you don't get to select the dissent until we get to select the dissent.
Right.
And so, I mean, that seems to me jurisprudentially that's a different kind of problem that you have here.
That's right, but Again, I hope the court focuses on National Bell Assess and the burdens that were assessed at that time, sees Quill for what it is, stare decisis limited to a very specific circumstance. Thank you.
Mr. Barnacle.